Ready to begin? Both sides ready?
Yes, Your Honor.
Yes, Your Honor.
Good morning, Your Honor. May it please the court. My name is Patrick Brennan of A2 Law Partners, and I have the privilege of representing the petitioner in this matter, Dr. John Shim. I'd like to save 5 minutes for rebuttal.
All right, you got it.
Wonderful. This petition for writ stems from the trial court's ruling. Essentially, what the issue is Dr. Shim's, who is a non-party, his privacy right to his finances. In particular, there was a motion for protective order that was filed on behalf of Dr. Shim in the underlying case. Senior Judge Herbert Bowman on September.
Let me ask you, how he has privacy right when he throws himself into the controversy like he.
And that's not necessary. And I respectfully disagree with the categorization regarding him throwing himself into.
These highs and dividends.
Well, no, and I think there's in the Elkins case, it's clearly recognized that there's still financial rights to privacy. And looking at Florida Rules Civil Procedure 1.280, which was adopted after Elkins, clearly says an expert shall not provide financial, and I can read it because it's.
I've seen the rules. I've gone through this. I'm trying to figure out how to extrapolate his income, given the question he has been required to answer.
Certainly, and this is, in a practical sense, this is what happens. In this case, which is also in a practical sense. So there is a rate sheet or a fee sheet that's provided under the rules of civil procedure. And that rate sheet itemizes, obviously, whatever his charges are for deposition, trial testimony, compulsory medical examinations, medical records review, etc.
So wait, we've got it. What's the difference between this discovery? How many times, average time, how many CMEs on average does he perform a week versus the percentage of time he spends that the rule authorizes? What's the difference?
And that's a great question, Your Honor, and there is a difference. The percentage, and that's what I proposed to the trial court.
Well, isn't the extrapolation analysis the same? Because that's really what your case hinges on, isn't it?
Not in part, Your Honor, it does. There's an extrapolation in terms of multiplying just the number of CMEs.
Right, you can do the same thing with the percentage factor that the rule authorizes.
Arguably.
I mean, it requires maybe 3 calculations instead of 2, but what's the difference?
And so the difference being is you don't know, obviously the percentage of CMEs that he performs on an annual basis is less invasive. I think the analysis has to be a less invasive analysis. The percentage of CMEs that he does in relation to the percentage of the income that he derives from performing the CMEs on an annual basis protects the actual numbers. The numbers is what is being accessed.
But what you deny the other side, if I take your theory, is you are denying them an opportunity to explore bias, because according to you, he doesn't have to tell them how many, what percentage or anything. The rule allows that, and isn't the other side entitled to know how much time does he spend as an expert for a particular party?
Yes, Your Honor. Under the rules.
But you're telling me that if he can't answer that question, I'm taking away a tool of cross-examination of the expert.
Not at all, Your Honor. And I think where the balance has to be made is what is reasonable. And Elkins goes into a very well-detailed opinion by the Florida Supreme Court detailing that, hey, we've got to put up some parameters protecting these non-party experts. And that's exactly what the Elkins opinion does. And so, protecting these non-party experts from overly invasive and burdensome discovery requests is what the purpose of Elkins has been and what the subsequent case law has developed into. And so we're not preventing them from exploring bias because you still have the discovery from Boschert, a party, this is discovery from a party to a non-party. Boschert versus Allstate is a party to a party, and they get the information.
But the breadth of the discovery in Elkins was significantly different. We're talking tax returns, incredibly invasive financial discovery. This is at best a tool to extrapolate.
Your Honor, I respectfully disagree. I believe you're putting together a puzzle. There's puzzle pieces that are going into this puzzle, and you're looking for a number of CMEs to calculate what his gross financial income is from expert services, which the rule says you clearly cannot do, and Elkins says the same thing.
Well, the rule also says you can establish bias through cross-examination based on a financial interest. And which is why, and I don't think Elkins has a whole lot to do with what's going on here. It's easy for me to understand why the information in Elkins would be protected under the constitutional right of privacy. It's not so easy for me to understand. And that's your burden here. You're on a certiorari. You have to show irreparable harm that can't be remedied on preliminary appeal, and a departure from the essential requirements of law. And even if we assume, for purposes of the analysis we have to do, the existence of the first two prongs for jurisdictional purposes, the essential requirements of Elkins is not an essential requirement of law that would apply here because of the quality of the discovery. But the rule of civil procedure is an essential requirement of law, and it authorizes something very much like this. So that's where I'm struggling with your case, and I'd appreciate you addressing that in the context of our certiorari jurisdiction.
And Your Honor, and I think the focus is the departure of the essential requirement of law is if you look at the ruling and look at the order, there is no analysis. There is no identification of the.
Well, the trial judge can rule, there's no requirement to provide an elaborated order here. I mean, we're presumed on this part of the review to be capable of analyzing what the trial judge did legally.
And Your Honor, looking at what the trial judge did in this case is he failed to identify any kind of compelling interest between the need for the discovery and.
But wait, the trial judge had a big long hearing, talked about this, and the transcript is long, and while it concerned other matters, I think it's an unfair description of what the trial judge's boots on the ground analysis during this hearing to say that he didn't do any. The fact the order, I assume, was a prevailing party, whoever that your opponent prepared the order, let you look at it, and the judge signed it. But to say that because this is an unelaborated order, the trial judge didn't do analysis, which is what I think you're saying, is belied by this record, in my opinion.
And Your Honor, looking at the analysis, looking at the trial judge's reasoning, I quote to you, his basis for the order, bias is always an issue. And that is that, in his opinion, the number of CMEs is a legitimate issue to ask an expert who's going to testify. And that's at page 69 of the appendix.
And does that depart from the essential requirements of law? Is that your argument?
Your Honor, it does. And looking at
it's akin to what 1.280 allows. So if the question is, what percentage of time you spend doing these, you have no problem with that.
Well,
or you're going to tell me the privacy right trumps 1.280.
Well, the privacy right is, there's a constitutional right to privacy in addition to a privacy right that's been recognized by the courts that's been adopted in 1.280. And so both of those do apply to this situation. And in looking at it, it's an approximation of the expert's involvement as an expert witness, which may be based on number of hours, percentage of hours, or percentage of earned income derived from serving as an expert witness. Now the difference is, and my colleague here in opposition states that the question of is a very similar question to the number of hours that petitioner spends in a week acting as an expert, which is a part of the above rule. It's not, but there's a difference because Dr. Shim does not charge based on the hours he's performing these CMEs. He charged per CME. So it's a distinguishing factor between what the rule allows for and versus what how he bills. So he doesn't bill per hour. He doesn't say, okay, well, CME is going to take me 1 hour and my hourly rate is $11.50.
Well, let's come back to the rule because you've agreed that the rule applies, and we're looking. You need us to find a departure from the essential requirements of law. And what the rule says is the expert shall not. It says what the expert can be required to disclose in the way of pieces of the puzzle, as you called it, going to the bias issue on his finances. But the last sentence of the last clause of the rule says the expert shall not be required to disclose his or her earnings as an expert witness or income derived from other sources. If the trial judge had ordered your client to disclose his earnings as an expert witness, which the trial judge did not, then we would have something to talk about as a departure from the essential requirements of law. But all this trial judge required your client to do is something, then we've beaten this horse, very close to, and perhaps the same as, and your opponent's going to tell us why it is, but the percentage of time he spends serving as an expert witness, which to me is a lot like how many CMEs do you perform a week?
And I disagree because of the fact that
Because couldn't you ask your client how he spends the rest of his, if he does 18 CMEs per week and they take an hour each, how many hours a week does he work? What else is he doing? You know, I mean, that gets you the same place the rule gets you.
Well, and I don't necessarily see it the same way because it's the percentage of the time that he dedicates to performing CMEs, and then that still has the same effect as soliciting the same bias information that they're looking for.
Which is the information that the rule allows them to.
Yes, Your Honor, and I agree with that. And so what I disagree with is having a finite number or an approximation of the number of CMEs that he does. You take that, what his rate sheet is, because they're entitled to know what the compensation is that he received in these cases. You already have a deposition trial testimony list. You know how much he charges for a deposition. You know how much he charges for a trial. All you have to do is say, okay, well, how many CMEs do you perform? Boom. You put all the pieces together and there it is. That's what his expert financial income is.
But that's not what the rule precludes. The rule doesn't preclude that. The rule precludes disclosing earnings as a general proposition, which is, I think, what was, and I think it was designed to remedy and prevent future occurrences of the Elkins scenario. But
Well,
how much money he makes as an expert is fair game for impeachment.
I
and
disagree.
bias.
The rule says the expert shall not be required to disclose his or her earnings. Earnings as an expert witness.
In
That's what he's
gross.
Yeah, that's what he, that.
But the expert can be allowed to, and the trial court can require the expert to disclose an approximation of the portion of the expert's involvement as an expert based on number of hours, percentage of hours, or percentage of earned income, but not in gross, which I think is designed to address the constitutional protection in general, as opposed to the specific need. It's a balancing.
I understand that, and looking at the balancing right, I would argue that the constitutional right to privacy, in addition to the right to privacy that's been recognized by Elkins in the Florida Rule of Civil Procedure, trumps any collateral issue, any impeachment information that they would otherwise obtain that has the effect of soliciting his finances. And looking at the Lind case, which is a 4th DCA case, and it clearly states in Lind that it's the number of hours an expert performs, expert work, private expert work in a given year, and the hourly rate information has the effect of disclosing an expert, a non-party medical expert's finances. And it's looking at that 4th DCA case, looking at that, this has the same effect.
That's your best argument here, right? Lind controls and establishes the essential requirement of law from which the trial court departed.
Lind in part recognizes that financial right to privacy for a non-party medical
I
expert.
assume when you do any CMEs, I'm assuming the doc knows in advance that there's going to have to be a disclosure of his rate per procedure. Is that fair?
I think that's a fair conclusion.
So one enters the business knowing that this is going to have to be disclosed.
Well, I think in part, the hourly rate information, what you're actually getting paid is going to be disclosed.
You know that going.
Well, I think over the years,
It is part of the deal.
if a doctor is customarily involved in those matters and they become involved, they become aware of that, yes. So. Yeah.
So it undercuts the privacy argument, doesn't it?
Well, not necessarily. I understand that argument. I think just because they have a knowledge of what the hourly rate chart or what those rate sheet will show, I don't think that's necessarily to assume a waiver of a privacy right.
Mr. Brennan, I don't want to interrupt you, but you told me You wanted 5 minutes for rebuttal. If you stop now, you'll have 5 minutes, or you can keep going if you want.
I'll
Save it.
save it. Thank you, Your Honor.
If this court, my name is Brian Lee, I'm representing Robert Cruz in this appeal. I want to go back to just and what the court operated is. Obviously, we're on a petition for search warrant. And so we're looking at a specific issue. We're looking at the question that the trial court allowed a plaintiff's counsel to ask Dr. Shin. We're not looking, or at least the court is not looking at what becomes after that. There's a lot of speculation that I've heard or that you've seen in the petition itself as to, well, what can you do with that information? Can you ask these questions afterward? Are those questions relevant? Are those questions things that the trial court can do? That's not before the court. The trial court has the ability under discovery, which is what this is, to make those determinations as to what is discoverable and what's not. And under the certiorari standard, obviously the court knows we have to. Has to be irreparable harm, it has to be against the essential requirements of the law. We don't believe they get to the irreparable harm part, Your Honor, is because of the fact their whole argument is that, well, it's irreparable harm because it deals with the private finances of Dr. Shin. It does not. The court's already looked at the rule. I would submit that when you look at Elkins, and when you look then at the rule that happens, the court in Elkins, obviously, as we put in our brief, had a question almost exactly like this one. The district court decided that question was proper. That was the one they were going to ask. Was it going to allow all the taxes? Was it going to allow all that information? But it was going to allow that question to be asked. And the Supreme Court said, we agree with that. Now, it didn't find its way into the rule, but did it? I think it did. Because what the rule says is that not only can you get an approximation and hours percentages, whatnot, but you can also find out what the expert has done in that particular case and what is the compensation for that service. That's the first part.
So your opponent's best case for a departure from the essential requirements of law does seem to be the application of Lind. Could you speak to why Lind didn't bind the trial court and whether that was a departure from the essential requirements of law?
Sure. Lind was a per curiam opinion.
I don't think that matters.
Pretty
It's a
short
written
one,
opinion.
but yes, but what it required, and I'm looking at my response here, just to make sure, what it required, or excuse me, the order in Lind was quashed because it required the expert witness to disclose the number of hours in 1995 for private expert work and hourly rate information. Okay, so they made it, now we don't know the context behind that decision because it doesn't really give you the facts or thing, but the fact that they're putting in there that it was for private expert work, that means something, at least to me. It means that the court was not saying this is expert work that's through litigation. Obviously, Rule 1.280 contemplates litigation. That's what they're there for. And so the court in Lind, at least what we can see from the opinion, the trial court was going beyond that. Was going to not just what you do for litigation, but what you do for your quote private expert work. And that is, I think, Judge Rick, you were talking about that. You were saying that there are different things that experts do, or that we would qualify as experts. They do work for litigation. They could do work, frankly, for litigation that never sees the light of day. They could be a consulting expert. They could do other things. They could do records reviews. They could be called as a treating physician in a case. And so, which may clarify them as expert work in some sense. So what the court is saying in Elkins, what the rule is saying, is that that part of your work, that is what expert litigation work, that's what they have the opportunity to get to, the plaintiff or the defendant. Again, Elkins talks about it that it's both ways. You do it both ways. And so when we're talking about what exactly the trial court rule, even if you get beyond the irreparable harm part, we don't think there is one, any irreparable harm, because if it's not private financial information, there is no irreparable harm. They can't point to anything else that this would cause irreparable harm to Dr.
Well, it
Shin.
would be really hard for them, I think, on a plenary appeal if the jury, you can see where this goes for the appellate argument on a big verdict, right? So.
Sure, and I think ultimately it comes down to the reasoning for it. The trial court in the hearing, and it's very clear. I mean, I would suppose that I know this trial judge. This trial court knew what he was talking about. He had seen this before, and he talked about bias as being something literally that is on every single witness in front of this courtroom, and especially on an expert witness who has injected himself in litigation. And that's what he based his opinion on, is that it is bias. There is nothing that you've heard, and frankly that you can't hear from the petitioner on that, because bias is obviously something that is under there. What you're hearing from petitioner is that, well, because he said an average amount of CMEs, well, then that means that he's really getting into this financial information. It is not at all. It is akin to the amount of hours that the rule specifically says that a trial court, not even a trial court can allow, that the rules allow. And so even if you get to the essential requirements of law, the trial court followed the law, period. He allowed essentially what the rule says you can allow. Bar none for any other cases that were in front of him, he allowed them. And so when you get to the point of looking at this, what Dr. Shim is wanting this court to do is extrapolate CME different than what the rule is. What he's wanting you to do is he's wanting you to take one question that the trial court allowed and then say, well, because of all these other questions that could be asked, that you should find you should follow, or excuse me, you should grant a petition based upon that. I've never seen this court do that. Never seen any court do that, because you can do that on every single case. If I was allowed to come in and say, well, the trial court is going to allow this witness or this officer to talk about the observations that he made at the scene, well, I want a petition for certiorari because he can then ask them, what he put in his report. I mean, you're going down the road of what you could use information for that the plaintiff, Mr. Cruz, was absolutely entitled to get, and how that information is going to be used. This court doesn't need to worry about that, because that power goes to the trial court. You haven't heard anything about what the information was used for. There's nothing in there. And so the trial court ultimately has the ability to not only allow discovery, to grant or deny a motion for protective order as the court sees fit, but also how those parties are going to use that information. That's what the trial court has. And in this record, in this case, there is nothing to show that this trial court departed from any essential requirements of law. In fact, he followed it. I think I may have some more time, but unless the court has any questions for me, I'll rest on that.
Okay, so Brian, you've got 5 minutes.
Thank you, Your Honor. And just to recap, I understand this is on a petition for writ, so those 3 elements have to be met. This is a non-party. The Dr. Shim is a non-party, and non-parties don't have a right to appeal. As seen in the Katzman case, Price versus Hannes, which is a second DCA case, and the Heck versus Barron 1D case, which was cited in our reply, second DCA. With respect to number 2, resulting in injury for the remainder of the case, I understand the general rule is it cannot be speculative. I get that. However, here, this is the cat out of the bag type discovery, which was recognized not only in Katzman, but
Well, let me back you up real quick. I don't want to use up all your rebuttal, but I get the part about non-parties can't appeal. Then that would be a good response with respect to the constitutional issue, right? For purposes of certiorari and irreparable harm. But here, the real harm from this bias, aside from whatever constitutional interest, and we've talked about that already, would be the impact on the defense of, or on the plaintiff, of having this expert's financial circumstances put to the jury associated with his expert work. And that's going to be tough on plenary review to turn into a reversible error, isn't it?
well, Your Honor, I think the material injury is to Dr. Shim. I think we have to look at in terms of Dr. Shim.
I hear what you're saying, but I wanted to see if you acknowledge that there is another part of this that would be relevant or could be relevant on plenary review and why it could lead to irreparable harm or not.
I understand what you're saying in terms of with respect to the parties' positions, but Your Honor, I'm not following maybe entirely, so. But in looking at that, and looking at those cases, this falls under the exception. Dr. Shim is injured by the effect of having to disclose his finances. Looking at the Lind case, the trial court did not follow the law. This is an essential departure from the law. Looking at Lind, the 4th DCA case, which is applicable to the trial court, which would have had to have been recognized, some balancing interest. They're looking at all the case law that's been provided. There's got to be some balancing interest, and you don't see that in the record. It's not in the record. It was argued to the judge, and it was explained to the judge. Use the percentages of CMEs that he does, or the percentage of his practice that's comprised of CMEs. That's a fair question. Getting his gross financial numbers from running the calculations, that's not, it's just not, there's no need for it. It's a collateral issue. It's based off of impeachment only. This has no relevancy to the underlying pleadings, to the allegations contained in the complaint, or the affirmative defenses that have been raised by the defendants. It's solely a collateral issue, and to allow the court to expose Dr. Shim's or have Dr. Shim's personal finances disclosed and potential for use and further injury to Dr. Shim, I think the trial court got it wrong. And looking at that case, while I was looking at 1.280, Your Honor, I don't think I have, there's a couple of cases that did further recognize that the stating that requiring a non-party expert to state the number of patients for whom he performed disectomies for, and this is in the Katzman case. Katzman was recognized as a hybrid, so he was a fact and an expert witness. They recognized that in that case, that computation stated the number of patients for whom he performed disectomies in each year and the amounts received during those years from a health insurance company versus his letters of production. That went to the underlying issues because it had to deal with the reasonable necessity of medical expenses. We don't have that here. Dr. Shim's charges for the CMEs aren't in dispute, and he's not a fact witness. It's clear that he falls under 1.280, those protections and the protections that have been iterated in Elkins. So, Your Honor, I don't have any additional information. I just thought it was quite telling in the Elkins case, requiring an expert to lift his visors with the jury to see who he was, what he represented, and what interest, if any, he had in the results of the trial so that the jury could appraise his credibility, does not encompass the emptying of one's pockets and turning them inside out so that one's financial worth can be open to scrutiny. So here, Your Honors, I respectfully believe that that's exactly what happened with relation to Dr. Shim, and I'd ask that this court quash that order for the reasons iterated in the petition and the reply.
Perfect timing. Thank you both. Folks, before we call the next case, which will be the last case, we're going to take about a 10-minute break and then we'll come right back and do progressive back on track. We'll be in